Good afternoon. Please be seated. We are here at the time set for oral argument in file numbers 2026-0018 and 19, caption State of North Dakota versus Carl Stanley Snedaker. Mr. Carlspar, how do you pronounce your client's name? Do you know?
Snedaker.
Snedaker? Okay. Sitting this afternoon are Justices John Jensen, Douglas Barr, Mark Fries, and we have the honor of having Surrogate Judge William Newman sitting in place of Justice Tufte, who has disqualified. Ms. Krauspar, you're here representing the defendant, and Mr. Bromke, you're here on behalf of the state. So whenever you're ready to proceed, Ms. Krauspar, you may proceed.
Good afternoon. May it please the court, Chief Justice, Justices, Counsel. I'm representing Mr. Snedaker. There's two issues before the court, and the first has to do with was the jury properly instructed on unanimity, and the second was several violations, Rule 608, 404B, 403. I kind of want to start with the second one first. I think that's more cut and dry. The other one's more of an obvious error argument. So the second issue at the top is, did the district court abuse its discretion admitting evidence in violation of Rule of Evidence 608, 404B, and 403? To give some context, these were GSI sexual contact case. There's two cases, CR 79 and CR 94, and there was three main complaining witnesses across those two cases. Mr. Snedaker took the stand in his own defense, testified, and then on cross, the state solicited questions. There was no objection to it, but did he have inappropriate relationship with essentially a young girl? Was there kissing? Did you ever tell this young girl to not to inform her parents? Basically, the questions that elicited responses about inappropriate relationship with a young girl that mirrored the three complaining witnesses. This is close enough to the three complaining witnesses that it was a problem, but again, was not objected to. So Mr. Snedaker said that no, he had not done that. And then afterwards, the state requested to put on a rebuttal witness, which would have been CG, which is a uncharged fourth complaining witness. And they put this on to prove essentially he was lying, which is in direct violation of 608. There's no exception to that. It's a proof of a specific instance to prove character is not allowed. There's no...
Is that to prove character if you're just trying to prove that he lied when he testified?
Yes.
Okay. I guess that's the answer you have to give me.
Well, no, it's the answer. Honestly, it'd be the same. I was trying to think of hypothetical scenarios to make it more clear. And the one, because 609 comes in a different context. So the way I was thinking about it is if the state asked on their cross-exam of the defendant, have you ever lied to law enforcement? And then as a rebuttal witness, and the defendant denied that. And then as a rebuttal witness, they called a police officer to the stand to say, oh yeah, I had an interaction where he lied to me. So that's patently, categorically not allowed under 608. We're not supposed to have trials within trials. It has nothing to do with the elements of the offense of the three complaining witnesses. Where you run into the ability to bring up prior bad acts within that 10-year frame is under 609. So he had a conviction for false information to law enforcement. That could be brought in under that, specifically under 609. But if you ask the question and the response you don't like, you're stuck with that response. That's what 608 is about. You can ask the question to essentially bring out information on the defendant's, well, actually any witness's truthfulness, basically whether they're being truthful or not. You can ask the question, but then you cannot bring extrinsic evidence, outside evidence, to prove or disprove what they've stated. You're left with the answer you're left with, which the court acknowledges in the record. The court specifically says, how do we get around 608? And then the state says, well, we need it because, this has left a false impression in the mind of the jury. Well, you're the one that asked them the question, so that's your fault. I mean, the rule exists for this very reason, to avoid, again, this trial within a trial, to avoid confusing the jury, because now we have another uncharged complaining witness saying this happened, he kissed me, he told me to keep this quiet from my parents, he tried to have this relationship with me when I was a minor. And there's been no so that's the 608 part, but the 404 part is that there's been no notice of this. There's been no notice that they're going to bring this up. But they certainly have this witness available, and I think asked the question to bring this witness in. So and there's other, before the trial, the state indicates to the court, hey, there's another girl that we can't charge out for, I believe they said statute of limitations reasons. So they've known about this particular witness the entire pendency of the case before they went to trial.
Ms. Crossbar, assuming that there had been notice and assuming the statute hadn't run, would that evidence have been admissible in the state's case in chief?
No.
Why?
Because you go through the three-step process, which I did in the brief, under 404B. Our first problem is notice. There was no notice. But if we're assuming that they properly noticed it, they would have to then explain what the testimony was being used for under 404B. They just list, so this is a conversation they also had during the trial when the state said, well, this could come in as an exception to 404B, and then they just listed all of them. And the trial court rightly pointed out, you've just listed them all. You actually have to, explain how you're bringing it in. And they went back to, well, this needs to be for his truthfulness to show that he's essentially, not being frank, that there's this other pattern of behavior of concealment of these inappropriate relationships, which, again, I don't think gets you past, so we don't have notice, but I also then don't think it gets past the prejudicial. I think it's confusing the jury. You're saying this exactly happened. I think that there's a Gaddy, post-conviction Gaddy, not direct appeal Gaddy, but post-conviction Gaddy is directly on point out of Cass County, where, the prosecutor, there was a conversation between the prosecutor and the defense that said, we're not going to bring this stuff in, and then they did. And the court, in its Gaddy opinion, went through how that is so damaging and prejudicial to say that there is essentially the same conduct, uncharged, from a witness that we're then going to put in front of the jury to essentially, it's propensity evidence. It's not allowed under propensity. So I don't think you make it through any of the 404B analysis, and then you have to get to the weighing part, the 403. And there was some weighing on the record, but essentially the only part of this testimony that was not allowed to come in was specifically the act of kissing, which doesn't cure the propensity evidence of it. It doesn't cure the notice problem. It doesn't cure the propensity prejudice, because you're saying that there's a fourth. Now you're saying another person, and this happened before the time frame that the state's alleging on the three complaining witnesses that they did charge out. They're saying that this witness was told not to, tell her parents about the relationship or what happened between them. And so you have a real danger, just like you had in Gaddy, of them convicting because, well, he did it before these three came forward, and so he's obviously just doing it again. So you have a 403 balancing problem, and just across the board, I don't think it makes any of the tests, any of the three.
I'm not sure I'm going to pronounce it correctly. Mr. Bromke cites PROCIV or PROCIV in his brief. You don't. How do you distinguish your argument from the court's analysis in that case?
You're going to have to I'm going to have to look at it again, Your Honor. I'll have to bring it up. So I don't know. is the main, my answer at this point, but I do have some time on rebuttal, so I should be able to answer it after that. Or if I just look at the facts to determine why. I know in the state's brief, so my main problem with the state's brief was that they keep trying to argue that this has to go to his character and his credibility, which is not what it's being used for. Because if it was, 608 would keep it out. If that's what this was meant to do, to address his character, then it can't come in. Categorically, it cannot come in. So that was my main disagreement with the state's analysis in their brief. And also, they argue, they want it both ways. They argue to the court, we need to have this witness to sort of rebut this false impression that was left with the jury, which you can't do under 608. And then they're saying, but also it's fine to bring it in under 404, even though there's been no notice. As a surprise 404 introduction to the court, to the defense. No one but the state knows that this information is potentially coming in. This is the exact kind of reason in Gaddy that the court said, you need to give notice so that the court can review it and address it properly, so the defense can review it, investigate it, and address it properly.
Well, how could the state know that before your client testified?
You're the ones that asked him the question, with the witness in the wings, waiting to call him in. Again, they can ask him anything they want about credibility. But 608 says we can't then bring in extraneous evidence to support if you get a bad answer. You asked him, hey, do you take drugs? And he said, no, I don't take drugs. You can't then just call in witnesses to say, yeah, I was with him on Tuesday when he was...
So you have to get them to fall into the pit. You can't let somebody else dig the hole for them.
The rule's pretty clear. They have to... How it's typically done is with convictions, because those are the straightforward ones. I have seen, attorneys that will ask the question because they don't think that the defendant is going to come across credible. So they'll ask the questions. So you are all around, for example, I see it a lot in drug cases. So you're hanging out with this drug dealer and you're at a scene of an overdose. Have you ever done drugs? No. Okay, moving on. That's how you attack it. You don't then just bring in everybody who's at the trap house to testify, yeah, I saw him taking drugs. That's not allowed, because again, you get into the trial within a trial problem. And even the state doesn't believe that's, well, I can't really speak. I'm speculating. The state doesn't appear to that being their only reason, because they make the 404B analysis, which you wouldn't need. If this was strictly for credibility, you wouldn't need that 404B analysis. It's unnecessary because it's not an exception. It's just not prior bad acts or character evidence. It just isn't. It goes to his credibility. So you wouldn't need any of that 404B analysis.
So assuming we agree with you
Sure.
on Rule 608, why couldn't this be considered to be harmless error, considering the quantity of evidence that there was and the small amount of testimony by CG?
Well, again, it goes to the propensity, and I think that's the real problem. Is
even with the
well, you have three
with the special instruction to only allow it for certain things. I mean, looking at this all.
Yeah, that's never cured, sorry. My opinion is that's never cured the problem. If it did, Gaddy wouldn't exist, 403 wouldn't exist. Like, this eliminating instruction is your only option when something has come in. But that's why we have that 403 balance. Is this going to be insurmountable, that the jury's going to be like, well, he did this years before these girls even showed up. This is a pattern of behavior with this guy, because it's really, they're alleging 1 month and then another month in the conduct with the three complaining witnesses in the cases that were charged. This is prior to that. So he's saying, oh, he did it prior to these 2 months. And this is a witness that came forward and said this is the same kind of conduct. He's been doing it this whole time because he did it there. He's obviously been doing it. That's that's the problem with 404B. That's the problem with not giving notice. That's the problem with charging individual instances of conduct like was charged in these cases. None of the three girls were charged out as continuous sexual abuse. They're all charged out as individual contacts, which is why I think it's even more prejudicial, because you're saying you're basically creating a continuum from the 404B instance all the way to July and August of the complaints that happened then. But this kind of transitions into my first issue, which is there's no unanimity instruction on, they have to agree on what the contact was. This is the other thing that the state's been doing, not just in this case, but I've argued this several times to this court, because it seems like a pattern of behavior with how these are charged in informations and then how the jury instructions are written. They're written so broadly that almost basically everything that these girls testified to could substantiate that element of sexual contact, because we have cases like State v. Hagen, and then the Hake site, the H-E-I-C-K, Hike case that I cite, that says that pretty much anything can be intimate area if given the context of the situation. So in that Hike case, it's, he's stroking her hair and her face. In the context of that specific case, this court said, no, that could be intimate areas given what he was doing at the time. And so that contact counts. So again, with that broadly defined intimate contact, all of and I specifically point out in my brief where the jury could find intimate contact occurred based on the testimony, and that's multiple times throughout. And so where we have a problem is then we don't have a unanimity instruction on, the jury has to agree unanimously to what contact. So was it, and even the court points this out in the jury instructions, or when they're discussing jury instructions, the court points it out. But then there's no real cure to it. They don't cure the problem, because the instructions are still, the elements are still left the way pretty broad, and there's nothing in the charging document. I'm sorry.
If there is a Martinez-Gaddy unanimity problem here, was it waived?
So I don't think that it was waived. The court submitted the, it might be forfeited, but not waived. If I'm so I think that we can look at it under obvious error. The court brings it up. The trial attorney brings it up. The court had supplied the jury instructions. These didn't come from the defendant, so it's not like he submitted.
And then the defense attorney says, yeah, we're good, or something to that effect.
To me, is the non-objection. So again, that's forfeit, not waived.
It's agreeing to the instructions under our case law.
I think we're good is the same as I'm not objecting. So that's the same thing. It'd be different if he submitted the instructions and said, these are the instructions I specifically want, and then there's a problem with them. But these are court-submitted instructions. The court identifies this as a problem, comes up with a solution. He said, okay. If he said, okay, I'm good, whatever. Those are all, again, I think that is more of a forfeiture, not a waiver.
My recollection is we have cases where the specific question was, any objection? No. And we said that was a waiver, not a forfeiture.
That I don't think is true, because we had, I think Stud Horse was, which is this type of unanimity problem. That was, there was a, and I'm trying to remember specifically the facts, but I think Stud Horse, he was a non-objection or no objection. I think where I've run into problems, or where I've tried to argue that an obvious error did not apply, was when the defense submitted the instructions. Because the defense gave you the instructions and then can't turn around. I mean, I can, but it just doesn't seem to go anywhere with this particular court, which makes sense. I can't really say that if you submit, that's more of a post-conviction argument. That's more of a, did my trial attorney submit bad instructions? This is really a court problem, because even the court acknowledges that this is a problem, but then they don't actually fix it. They go through, so the court goes through and asks the state to identify what thing that they're talking about, but then they don't include that in the instructions to the jury, so.
Why is the unanimity issue not resolved by the distinction in dates and the identity of the victims?
Because as I go through in my brief, each victim talks about multiple contacts.
But the jury would have the elements of the offense and the instruction as to what would have to be proven with respect to each count, and they vary enough that there should not be confusion.
Yeah, but what the instructions I'm talking about is that I believe he touched her breasts on August 3rd. You believe that he grabbed her butt on August 4th. We both use that conduct to find guilty on count 2.
But there was an instruction as to what constitutes offensive or sexual conduct, correct?
Yeah, but both of those, so yes, to answer your question succinctly, but both of those two things are sexual contact. So the problem is that you could have 12 different people identify 4 or 5 different times where sexual contact occurred. There's not an instruction that says, all 12 of you have to agree that it was lifting her off the trailer and touching her butt. You have to agree, all 12 of you, that was the sexual contact that is being alleged here.
There was no request here for a special interrogatory, there was no motion for a bill of particulars?
No.
There was no objection made on the record, similar to the argument that you're raising here?
Well, where the discussion happened was when they were discussing jury instructions, and trial attorney did bring up the fact, like, I don't think we can identify, this is a problem. The court brought it up, the trial attorney brought it up, so I don't,
And they resolved it to the satisfaction of both attorneys on the record by separating the dates. The issue was really regarding only one of the victims, if I recall.
No, I think it's all of them.
But the attorney raised it as to all, or did only, you're raising it on appeal.
Yeah, I think there was a problem the court identifies it as across the board. And then I think that the court, to their satisfaction, asked for clarification from the state, like, what are you charging on what? And I think the state's response was, well, this is what I'm charging for this, and I'm gonna explain that in the closing, which they do. But that doesn't change the jury instructions. It lets them know that you all have to agree that this is what the conduct is, that we're, it can't be tickling her while her skirt's lifting up for the younger one. It can't, or it can be, I shouldn't say can't, it can be, but the problem is that you all have to agree that's what we're talking about, not the ATV ride. We all have to agree what conduct it is. And without an instruction that says, you guys all have to agree what conduct it is in order for your guilt, your conviction to be, your verdict to be unanimous. Without that instruction, it lets them do whatever they want. There's an instruction on unanimity, but it's just that they have to unanimously agree that he's guilty, which is not a step far enough. And so that's where I think the error is on the instructions. And I think that the court identifies that the problem, the resolution doesn't cure it. Just arguing to the jury what the state thinks they should find is not, that the state doesn't get to go in and deliberate with the jury, and so that's the problem. And I think that here we need to reverse, one, for the 608-404B under post-conviction GADI, and just the rule itself, 608 in of itself. But then also because of the jury instruction on direct appeal GADI is where we have a problem with unanimity. So I would ask this court to reverse. Thank you.
Thank you, Ms. Krausbauer, for your argument this afternoon. Mr. Bromke, whenever you're ready.
May it please the court. I'll start by addressing appellant's arguments on the evidentiary issues. First, counsel argues that the standard of review for all the evidentiary issues she raises is abuse of discretion. That is not the case. It only applies to the Rule 403 issue because that was the only issue that was preserved for appeal by Mr. Mottinger's objection. Her Rule 608 issue is only reviewable under the obvious error standard because it wasn't raised in the trial court at all and is therefore forfeited. As to the 404 issue, it's the state's position that that was waived. At trial, during a fairly long speaking objection, Mr. Mottinger initially referenced Rule 404 as one of several potential bases for an objection that the court solicited from him. After coming back from a break, he then clarified that there were two issues. One, we need an answer referring to a Rule 607 question of whether the proposed testimony of the rebuttal witness would actually contradict the defendant's testimony. And that specific request for relief, I believe, was partly granted on other grounds later on. And then two, I think the issue before the court is still the balancing test, whether or not it's more prejudicial than probative. That 403 basis for the objection, the court did explicitly address in detail and made what was effectively a finding that the probative value of the evidence was not substantially outweighed by the danger of unfair prejudice. The court then specifically asked counsel, are there any other issues, to which Mr. Mottinger responded, not at this time. To the extent that he brought up a Rule 404 issue during his lengthy speaking objection before the break, what the trial record reflects is that he abandoned it after the break, focused entirely on the Rule 607 and 403 bases, got relief on one, was denied on the other, and then when given the opportunity to bring any other issues to the court's attention, he said no. Then during the testimony of the rebuttal witness, Mr. Mottinger didn't object to any of the witnesses, any of the state's questions to the witness until the last question, when he objected at the point where her reply became non-responsive. It was something about a statement that was hearsay. The state also interrupted her to keep her from going down that path. Mr. Mottinger didn't advance a basis for his objection, and the testimony ended without cross-examination by Mr. Mottinger. That is an intentional relinquishment of an issue, I would argue twice, and therefore a waiver, which means that this court should not review the 404 issue based on the precedent in Guthmiller and Studhorse. Second, counsel argues that the state argued the testimony was admissible solely for impeachment purposes, but also argued that it was an exception under Rule 404B for motive, opportunity, and intent. She also argues that the state cannot simultaneously disclaim Rule 404B to avoid its notice requirement and invoke 404B to justify admission. The way this is written and the way it's presented to the court, I believe, creates a slight mischaracterization. The state offered the testimony to contradict the witness's testimonial statements, to contradict the defendant's testimonial statements. I believe my exact words were solely in rebuttal to the defendant's testimony. And then Mr. Mottinger, again, didn't object so much as the court invited him to address that, and then Mr. Mottinger opined about why it might not be appropriate.
Counsel, was the testimony during direct examination or cross-examination?
I'm sorry, who?
Was the testimony that the state wanted to rebut solicited during direct examination of the defendant or cross-examination of the defendant?
Cross-examination of the defendant.
I would like to just break this down rather than move back and forth between the two rules, because I think it gets a little fuzzy when you're moving back and forth. So 609B or 608B, okay? Two parts. One is no extrinsic evidence to prove specific instances of a witness's conduct. And then the second is during there's an exception during cross-examination. This clearly isn't cross-examination of the witness. This is a rebuttal witness, so it's not cross-examination, correct?
Correct.
So it's not the exception.
No.
So why doesn't, again, put aside the standard review for a second, why doesn't 608B apply? This is extrinsic evidence being offered to prove specific instances of a witness's conduct.
Because 608 only applies when you're attacking the character for truthfulness, or rather the character.
Okay.
It's not about.
So this isn't for truthfulness.
No, it's for directly contradicting a statement.
Okay, I'm missing the subtle difference between contradicting a statement and truthfulness.
Sure. Okay. I was going to get into that a little bit later. But
How is contradicting a statement not attacking truthfulness?
So the way that it's characterized in the appellant's brief, I believe rests on a misunderstanding, willful or otherwise, on the difference between attacking a witness's credibility through direct testimonial contradiction on the one hand, and evidence or testimony about the witness's reputation for truthful character on the other. Justice Freeze referenced, I think it's prosive or prosive earlier, which is exactly on point. This court
It's
treats
not on
those
point
as...
because it's talking about a different rule that doesn't have these exact prohibitions.
I understand that, but this court does treat the two concepts, direct testimonial contradiction on the one hand and character evidence on
So
the
this
other.
wouldn't, so under your theory, this wouldn't be admissible if you were trying to show, yeah, he lies all the time versus he lied on this witness stand today?
Yes, because that's not the
the
purpose for which
distinction
it's-
that you're
yes.
saying.
Yes, that is
That's
correct.
character, is he lies all the time.
Which is why I didn't offer it as character evidence. I offered it as a direct contradiction. It's made relevant by 401, and then 403 comes in, and you have to, I thought the 403 analysis was perfectly reasonable by the court, but yes.
But 401 and 403 don't have the specific prohibitions on allowing that, do they?
I
They don't.
don't believe so, no.
So that, you didn't cite any case that under 608 specifically, correct me if I'm wrong, that says this is allowable?
I don't believe that I cited that because I don't think that it would exist for the purpose that the court's asking for. You're asking about a 608 decision on character evidence in the context of me arguing that it's not character evidence, the
Oh,
purpose for
that's
which
what
it was
I'm
offered.
looking for, a case that says this comes in when it's not character evidence.
I don't believe that
Because this is
there's,
not character evidence.
right. Again, and I did, the reason why I had to cite a case that's not directly on point is because I don't believe that there was a case of that type.
Don't you think that's a little bit unusual for a rule that's been around as long as Rule 608?
I'm sure that it is, but I also think it's a little bit odd that the defense raised the issue of, well, basically conflated two things that are conceptually distinct for the purpose of, because what the defense is arguing here is that this court should collapse the distinction between those two concepts and then just treat all direct contradiction impeachment testimony as necessarily attacking a witness's character for truthfulness. That's bad public policy, and I would imagine that's probably why there isn't case law directly on point, at least not that I've seen.
Mr. Bromke, would this testimony of CG been admissible in your case in chief, had you given notice under 404B?
I don't know because I didn't intend to bring it.
And then you cite Prokive, or however you pronounce it. One of the big distinctions between that case and this one is the court in Prokive said the evidence that would have been admitted was admissible. Notably, I think the case says notably this would have been admissible in the case in chief.
Okay.
So how do you differentiate that holding from what you're arguing today?
I think that the only reason that I cited Prosive, if I recall correctly, was because I wanted to give the court the understanding, at least from my perspective, that there was a distinction between the two different types of impeachment, impeachment by credibility, character, and impeachment by direct testimonial contradiction. That I don't believe that I cited it for any other proposition than this court treats them separately in X contexts, is what I mean. So, the court specifically inquired of the state, does the state acknowledge that it's prior bad acts evidence? The state responded no, offering it solely for impeachment purposes. The court then confirmed which of the exceptions to Rule 404B applied in this situation, and since it wasn't being brought as character evidence, the state responded motive, opportunity, intent might apply, not because the state intended those to be the grounds for offering the evidence, but because they're alternative bases in case the court concluded that the evidence would be character evidence under 404B. And then I believe I reiterated to the court, the purpose was to rebut with specificity the testimony that the defendant gave at the end of his cross-examination. Moving on to the other issue with relation to 404B, the pretrial notice requirement. Assuming that counsel is correct that the 404B issue wasn't waived, counsel seems to be under the impression that I'm under an obligation to notice my intent to call as a witness someone that I can't call in my case in chief. That's not what Rule 404B requires, because the state can't build its case around the assumption that the defendant's going to get up on the stand and lie. The state had to prove that he molested those girls with the explicit presumption that he won't do that because he's under no obligation to do so. I can't even reference the possibility that he's under an obligation to prove he's innocent. Notice under 404B, where it's required, has to be given within a reasonable time to allow the defendant to meet it, and to do so in writing before trial or in any form during trial. The rule itself contemplates that the notice requirement might crop up at any point, including during trial. The only point at which testimony of the rebuttal witness becomes relevant and therefore makes the witness capable of being called by the state for any reason is when the defendant gets on the stand and opens his mouth. There's no earlier time at which the state could provide the defendant notice of its intent to introduce that evidence. So even if this court finds the issue wasn't waived, the three-step 404 analysis required was effectively performed, or at least the court engaged in the necessary considerations by that test. I would note that counsel for the defense didn't actually argue in a principal brief how the district court failed to engage in that analysis, and instead said we don't even get to that point because the state failed to timely provide notice. But as to the elements of that analysis, assuming that the court doesn't consider the argument waived, the court inquired as to why the state wanted to introduce the evidence. The state responded it was to impeach the defendant's testimony through direct contradiction. There was proof of the crimes charged which permitted the jury to establish the defendant's guilt independently on the evidence presented, that being the testimony of all the state's prior witnesses who testified in the case in chief. And the only thing I think the counsel could have but didn't argue was that the court didn't specifically inquire into the reliability of the evidence in the prior act, which is a consideration that ordinarily comes in when, for example, the state tries to introduce evidence of a previously recorded child victim interview, and the reliability of that turns on whether the victim was giving answers organically or pushed one way or the other by the interviewer. But the court certainly did engage with the witness's reliability because A, it acknowledged I'm certainly going to give you an opportunity to call rebuttal witnesses, and B, Mr. Moniger never, not once in his objection, questioned the witness's truthfulness. In fact, all of his responses to the court's inquiry for the sake of argument, assumed that she would say something that was truthful. He never actually disputed that, and he also never contradicted her or attempted to cross-examine her on her testimony. What the court was evaluating was a potential witness who would be testifying directly to things the defendant had said and done to her, which is among the most inherently reliable evidence that can possibly be offered at trial, short of video of something happening. And even if there was question as to its reliability, the defense had the opportunity to cross-examine her and elected not to. So after that, the court engaged in a Rule 403 analysis, concluded that the probative value outweighed the prejudicial effect. It's just a straightforward disagreement between the state and the defense. The state obviously argues that the court didn't abuse its discretion in allowing the evidence under Rule 403. Just to rebut her arguments with specificity, the fact that the district court adequately grappled with the 403 question is, I think, obvious by the fact that he excluded some but not all of the proposed testimony. Counsel misleadingly states that the state's asserted purpose was to attack Mr. Snedaker's credibility as prohibited by Rule 608, subject to Justice Jensen's considerations earlier that they may be connected in some way. The state never invoked any subject matter governed by Rule 608 is our position, and Rule 608 doesn't govern the testimonial contradiction, which was in fact the state's asserted purpose. That's our whole argument on 608. Counsel states that the court acknowledges the testimony was highly prejudicial because it's the same kind of conduct, but leaves out the fact that the kiss on the lips, the only act that created a specific prejudice concern that the court actually articulated, was excluded in favor of the defendant. And the court also specifically stated that putting someone on the stand and asking if he ever asked you to keep secrets is not so prejudicial that the probative value is outweighed. Counsel specifically characterizes telling a child to keep secrets from her parents and engaging in sexual or romantic conversations as describing a pattern of behavior identical to what the charged victims described. It's apparent from the record that this pattern of behavior isn't anywhere near identical to what the charged victims described, all of whom were molested in different circumstances and only one of whom was the subject of romantic conversations at length. And then counsel also characterizes the rebuttal testimony as describing conduct of the same character as the charged offenses as a basis for arguing that the limiting instruction was insufficient. That's also not supported by the record. The character of the charged offenses was defendant made sexual contacts with the victim's private parts, and that was much closer to the type of testimony from the rebuttal witness that the district court actually went ahead and excluded. So there was no propensity evidence put on by the state suggesting that because the defendant had molested someone in the past, he was likely to do so in the future. Moving on briefly to the jury instructions issue. The defense argues that the court's instructions and the verdicts in these cases suffered from an analogous flaw to State v. Gaddy. The problem is that Gaddy was a true count identification problem. There, the jury was presented with multiple counts of the same offense involving the same victim without instruction or verdict forms that adequately tied each count to a distinct factual event. So the concern was not just that the jurors might disagree about some evidentiary detail, but they might not be agreeing on the same crime at all. Some jurors could have believed one incident occurred, others could have believed a different incident occurred, and the verdict form wouldn't reveal whether all 12 agreed on the factual basis for the same count. That's the Gaddy problem, the multiple indistinguishable counts, multiple factual incidents, and no adequate mechanism, for example, delineating by date, ensuring juror unanimity as to which act supported which conviction. The defense tries to characterize this case the same way. Their argument is that the testimony described more than one alleged contact, and because the jury instructions didn't identify each count by a highly specific factual label, for example, the chicken coop incident or the hay wagon incident, the same unanimity defect exists here. But the state's position is that that argument overreads Gaddy. The final instructions in this case did not leave the jury with indistinguishable counts. They separated the charges by victim, where the same victim was involved, by date range. And without looking into Mr. Mottinger's head at the time, the reason why this wasn't a problem that was brought up immediately was because, with respect to the incidents involving ST, the evidence before the jury established that the hay wagon incident occurred in July, and then the other incident occurred in August. And then what the parties in the court were trying to establish was that one count somehow identified the chicken coop, one count somehow identified the hay wagon, such that the jurors wouldn't be confused in applying the facts to the charged crimes based on the evidence that had been presented. Mr. Mottinger repeatedly stated that he was fine with the time frames being used as a proxy for that. So that's materially different from Gaddy. The jury here was not asked to sort identical counts with no distinguishing information. They were differentiated by victim and time period, and the court instructed the jury that each juror had to agree to the verdict and that the verdict had to be unanimous. And then the jury, I believe, was also polled after returning its verdicts. What the defense is really asking for is something beyond Gaddy. They want a rule that whenever testimony describes more than one factual detail that could satisfy quote-unquote sexual contact, that the state must elect a particular micro-act, or the court must give a special unanimity instruction identifying that act. That's not what Gaddy requires. It requires enough distinction between counts to ensure the jury is not convicting on indistinguishable charges. So the defense's problem is not really a Gaddy problem. It is at most an alternative means argument dressed up as a unanimity claim. And critically, as Justice Newman pointed out, apologize if I got the name wrong, this was not an issue that the defense preserved and lost. The district court identified the potential concern. The parties discussed how to distinguish the counts. The state proposed date ranges. Defense counsel accepted those date ranges, and counsel repeatedly confirmed that the instructions and verdict forms were acceptable. Justice Barr referenced stud horse, and counsel got it exactly wrong. The issue was waived under exactly the same circumstances. Do you have any changes you want to make? No, I don't think so. Waived. So the court need not expand Gaddy to reach this case at all. There wasn't a Gaddy defect because the counts were not indistinguishable, and the defense accepted the very structure it now attacks on appeal. For those reasons, I would ask the court to affirm the verdict. Thank you.
Thank you for your argument this afternoon, Mr. Bromke. Ms. Cross-Parr, I believe you have 5 minutes left on rebuttal.
I want to address Justice Freeze on, we're going to say Prosic. It's a self-defense case. That's how I think of it. That is not a 608 question because it's not even they weren't attacking his character. They were attacking, or not even attacking, they were presenting evidence that it wasn't self-defense, which they're obligated to do. And her testimony was essentially, he told me that, I can't talk to you about it because I don't want to incriminate myself. So again, that's not even rebuttal. They could have put that in their case in chief, which is essentially what the case says. It's not rebuttal, that's not 608, that's not character. That has nothing to do with, there's night and day cases.
So there's a distinction between presentation of evidence as to somebody's character versus inquiry into statements to impeach them.
Right. Yes. But that's, I think, Justice Jensen, you're spot on. He keeps saying, well, we wanted to prove he was lying. That is credibility.
But what about the distinction? What about the distinction between generally attacking character and the rebuttal of specific statements made by a witness on the stand? Those two are different.
But that's not what they're doing. That just fundamentally not what's happening here. It's the same, it's every case I can possibly think of where you ask a witness, do you take drugs? Have you lied to the police? Are you...
But wasn't the defendant's avenue here, when the question was asked, to say objection, relevance, But once
No,
that,
but
once that moment passed,
No,
where the question was allowed to be asked, and the defendant says X, and X is untruthful,
yeah.
That's-
You're stuck with the answer.
no, are you? Because you're not attacking character then.
You
You're
are.
attacking a specific statement made by the defendant
that's-
while on the witness stand.
That's credibility. That is
Well,
credibility.
certainly it's credibility, but it's.
608,
But it's not character evidence. It's credibility, which is different than character evidence. This is a specific,
Because
comment.
then you have essentially opened the door to every single extreme. You get into trial within a trial.
The defendant's avenue here is to object to relevance. It's not relevant what happened with another child.
Yeah, but see, he didn't phrase it that way. He phrased it in a way that will allow him to call that witness. He said, "Have you ever done this?"
Objection, relevance.
Well, if they're talking about the three complaining witnesses, I think that would be relevant.
Clarify. Which child are you talking about? If you're talking about somebody other than these children, objection, relevance.
You would never be able to, again, this is specifically why 608 exists. So you don't do this. This is not about this is not about impeaching him.
Ms. Kraus-Barr, was there an objection under 608?
It wasn't labeled 608, but I disagree with the state's, he says you can't call her. And he's objecting to her testimony. And he is specifically saying that this should not come in. And I don't think it was ever waived. I think that he comes back and I think it's a general objection, and then I think he comes back and specifically objects as the state.
Under what, 404, wasn't it? 404,
Yeah.
403?
Yeah.
So under 608,
Mm-hmm.
if there wasn't a specific objection under 608, and now you're arguing on an appeal, doesn't that put this in obvious error as the state is suggesting?
He specifically says, I object to her coming and testifying. The court says, yeah, we have a 608 problem. And the state then says, no, we're not.
So by the court raising it, it's preserved as a
The
possibility?
court, I don't know how else the court could not, it is addressed by the court. The response by the state is, we're using this because we have to essentially rebut his statement, which is, that is dead center 608, because that is every time you ask a defendant a question about, do you take drugs, which is a very common question. Have you lied to the police in this? You could ask him, have you lied to the police in this investigation? And they say no. You don't then call up individuals to show that he's lying. What's specifically problematic is that they created this scenario knowing that this was a witness they wanted to call to get around 608. So I disagree with the state's analysis. Thank you.
Thank you for your argument this afternoon, Ms. Kraus-Barr, and yours as well, Mr. Bromke. This case will be taken under advisement, as all cases are, and court is adjourned until 10:45 a.m. on Thursday, June 4th, 2026.